Welcome back to Alberta Primetime. From a pot precedent to prosecuting drug-impaired drivers and Alberta court delays, it is time to fire up the vocal point. Joining us for the Wednesday Crime Panel, Rod Gregory, an Edmonton-based criminal defense lawyer. In Calgary tonight, Kelly Sundberg, chair of the Justice Studies program at Mount Royal University. And on the phone with us tonight, Jason Van Russell, justice and social issues reporter with Calgary Herald. Good evening, gentlemen. Nice to have you back. Yeah, here in Edmonton, we have lots of snow. So the fact that you made it, Rod, that's a good deal. Okay, the presidential ballot wasn't the only vote Americans cast on Tuesday. In the states of Washington and Colorado, voters approved legalization of marijuana for recreational use. In Colorado, people can now grow up to 6 plants and possess up to an ounce, but still cannot use the drug in public. And in Washington state, there will be a licensing system for growers, processors, and retailers, and freedom for adults to buy up to an ounce of pot for personal use. Rod, I have to say, I was surprised Monday night watching a Seattle TV station. I saw a commercial pushing for this, a yes in this vote. How surprised are you that it did, in fact, receive the yes nod?
I'm not that surprised. Over the last while, the U.S. has really adopted medicinal marijuana, and there's been a push from the states, i.e. the criminal law in the states themselves, not the federal criminal law, to decriminalize marijuana because the costs of incarcerating people are so high that there's even been a push from Republicans to decriminalize marijuana. So I'm really not surprised.
Kelly, I would have thought that this would have happened on our side of the border before we'd see it in the States. What do you think?
Well, you know, for the longest time, we've discussed that we haven't relaxed our laws around personal use of marijuana because it would cause these issues with our neighbors to the south. You know, I think it's the cost of enforcing marijuana use for personal use is prohibitive, and I think that this is a move that we're going to start seeing not just throughout the United States. I'm sure we'll start seeing movement like this in Canada and throughout many other Western nations.
But Kelly, what does this say about the war on drugs?
Well, it tells you that the war on drugs or the war on pot, it wasn't successful. And when we see the costs that state governments have incurred in the United States because of enforcing small quantities of marijuana and how this has caused a great burden on their justice system, you know, this is a clear indication that those efforts were probably short-sighted, and that now the states, some of the states and a lot of states are moving this way, are relaxing these as a means of addressing these costs that they've incurred over the time, and to be realistic on the use of marijuana use for personal use.
Jason, part of the sales pitch in Washington State and in Colorado was the millions of dollars in tax revenue that this could generate. Might that spur a bit of the discussion on our side of the border to bring such legislation here?
That's certainly one of the arguments. There is I would say, a growing decriminalization movement in Canada that, like in the States, has sort of picked up some credibility over the years as politicians from all political stripes sort of sign on to the cause, as well as you know, some prominent law enforcement and retired law enforcement people. However, you know, one of the big arguments that's really being advanced in Canada, particularly in BC, where there's a coalition called Stop the Violence, and what they're doing and what they're advancing is that by regulating marijuana, you know, you're taking a real revenue stream out of the hands of organized crime, and by doing so, probably reducing the amount of violence that's associated with the drug trade. No doubt, you know, no doubt the people who want to decriminalize marijuana do point to the possible revenue benefits from regulating and taxing it. But at least so far in Canada, you know, a good measure of the pro-cannabis debate is centering around trying to reduce gang violence by taking away cannabis as a revenue generator for organized crime.
Now, to build on this discussion, the Washington state measure includes a standard blood test limit for driving under the influence. And it was just today that MAD Canada, Mothers Against Drunk Driving, took aim at our country's current approach to identifying and prosecuting drug-impaired drivers, saying it does not work. Jason, we're well aware of the prevalence of alcohol-impaired driving in our province, but what about the narcotics element? How big of a problem is it?
It's likely a bigger problem than police are really able to get a handle on it at this point. As far as making a concerted effort to enforce drug-impaired driving, it's been only in recent years that police agencies have gone out and trained what they call drug recognition experts, who are able to administer roadside and further testing for drugs, on evidence of impairment by a driver. For example, in Calgary, they've got about 20 active drug recognition officers who can be called to the scene of a suspected impaired driver at any given time. They didn't have any hard numbers when we last asked them about this, but they said, they're laying charges every other week. When you think about that in the grand scheme of things, that's not a lot. About 915 drug-impaired driving charges were laid across the country in 2010. That's the whole country. So, this is definitely I hate to use the marijuana-related pun, but this is definitely a growth area, likely for police. And, part of the thing is that it's been up to the RCMP to be training drug recognition experts over the last couple of years. And Calgary Police has 20 DREs, but there's basically some who are still in the pipeline and haven't yet been trained and put on the street. So I think as law enforcement maybe clears up a bit of that backlog, you will see some more charges being laid. There's certainly no lack of willingness on the part of police to be enforcing this aspect of the law. What we haven't seen is a heck of a lot of people qualified to be able to do it.
Kelly, do you agree with that? Is law enforcement prepared enough for this? Justice system as well for dealing with stoned motorists?
There is Australia. They have a roadside screening device of sorts. It's a device that rolls across the tongue that can identify cannabis residue. It's been very effective with the Victoria State Police especially. And I just want to say that I think that it shows that when Washington relaxed the personal possession laws, that they were responsible in introducing tougher sanctions for those who toke up and drive.
Rod, were marijuana to be legalized on this side of the border, should we then brace for a flood of drug impairment charges?
Well, scientifically, I think it's easier to quantify impairment and alcohol use than it is drug and impairment in motor vehicles. So I understand that there are different technologies out there, but it's a very subjective area, and it's very difficult to quantify marijuana use and impairment. So you can measure that a person may have consumed marijuana, but it's very difficult to equate that to a level of impairment. So it's very difficult at this stage technologically to quantify impairment for drugs.
All right, up next, drop charges. Are the wheels of justice grinding to a halt? More with our Wednesday crime panel after the break. We're back with the nightly Vocal Point and our Wednesday crime panel to the growing debate now over a case where sexual assault charges were stayed because of delays in going through the courts. An Alberta family says the justice system has failed them after a judge dismissed the case because it took too long to go to trial. Some members of the opposition claim it's due to a lack of prosecutors. Jason, what's really at play here?
I think there are a number of factors. What you're referring to is Wild Rose MLA Rob Anderson had brought this up in the House last week, and things kind of went from there. It created, I think, a larger debate about judicial delays and just where we're at in the system. In fact, the number of prosecutors in Alberta has gone up over the last few years. I do believe, I looked at it just before I left work, I think we're over 300 now, and there'd been an increase of about 60 to 70 over the last 4 to 6 years. That's not necessarily to say that number that we have now is enough, but I think it's only one indicator. Generally speaking, you're averaging about 6 months to wait to go to trial in Alberta. It's what they call trial lead time, and this is the time from when your case has kind of gone through all the routine procedural appearances, then you get to a point where the Crown and the prosecutor say, or the prosecutor and the defense say, okay, we want to book a trial. On average in Alberta, you're waiting about 6 months from that point to get a trial date. And that can be influenced by any number of factors. It could be the fact that the courts are tied up. It could also be because of delays brought on by the defense. So when you look at those numbers about how cases are going through the courts, yes, institutional delays and perhaps a lack of resources on the part of the Crown are a part of it. However, the defense does play a role in these things as well.
Rod, Jason opens up a door there. What degree of responsibility did defense counsel
Well, the
play
interesting thing is the Supreme Court of Canada said that a stay of proceedings for a delay will only be granted in the clearest of cases. So if I'm a defense lawyer who's raising that argument, if I'm doing a delay argument properly, I have to chart every single court appearance. I'll have to have transcripts of every single court appearance to show why my client was prejudiced and the cause of the delay. If I adjourned a trial, that segment of the trial doesn't count for delay. So it's actually very rare that cases are stayed because of delay. Prosecutors do everything they can to move cases forward, and so do judges. And defense lawyers dragging their heels will not guarantee their clients having their cases stayed. It just doesn't happen like that. I will say, and I will agree with Jason though, that the provincial courts and the judges in Alberta are screaming for more judges. There are enough defense lawyers and there are quite a number of increases of prosecutors, but there aren't enough judges to hear the cases. I think that's where there's a real bottleneck, is if there's a backlog, it's because we don't have enough judges.
Kelly, you get last word on this one. Sign of a broken system?
I don't think it's a broken system. I think there's definitely area for improvement, and just the point of needing more judges is a one very key aspect. Other provinces have had similar criticisms. I know a few years ago, the Attorney General of Ontario hired Deloitte to do a program called Justice on Target, where they looked at streamlining processes within the courthouses to get that lead time reduced. I think that it's not as prevalent as the opposition party is making this out to be. They do a great job here in Alberta. I do agree that we need more judges. I think we got enough lawyers, but we're doing it. We're doing a fair job here. And I mean, there's place for improvement. But I think Albertans should be very happy with our system and how it's rolling out.
Okay, we may not make it all the way around the table on this one, but let's turn our attention to federal politics and C-309. That is the private members bill raised by Alberta MP Blake Richards. It has now received approval in the House of Commons and will ban people from wearing masks and hiding their identity during riots. Jason, how necessary is this law?
Well, I'll make it very easy to go around the table, all the way around the table by keeping it short. Not very necessary. To me, it's a frivolous law, and it just raises a whole bunch of questions. One of the things at the G8 summit in Toronto, when they had all those mass arrests, and they kind of picked over and did a post-mortem, was that police had a hard time separating legitimate protesters from the troublemakers. Why you want to muddy the waters further and get into who should be wearing a mask and who shouldn't, it's beyond me. I don't think it's a really valuable law at all.
Rod, not a whole lot of time, but as a defense lawyer, were you to have to defend a case where someone is charged with this?
Well, it would never pass constitutional scrutiny. I agree with Jason. It's absolutely ridiculous. There are over 800 sections in the criminal code that would cover almost every circumstance in terms of riots and public uprisings. It's mind-boggling what the government does some days.
Your message would be then, bring it on?
I would say bring it on. Bring it on.
Kelly, I think you have about 15 seconds of final comment.
I'll keep it simple. It's just ridiculous law, and just ridiculous.
Short and sweet. Gentlemen, thank you kindly. That's Edmonton defense lawyer Rod Gregory, Kelly Sundberg, chair of the Justice Studies program at Mount Royal University, and on the phone tonight, Jason Van Rassel, Justice and Social Issues reporter with Calgary Herald. Gentlemen, thank you kindly.
Good night.
Thanks.